Missing witnesses at trial. Are they fair game during summation? You want to learn the answer? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. There are many times during the course of trial where the defense will not bring in a particular witness. And as a result, we may be entitled to get what's called a missing witness charge. Now, here's an example. As part of your lawsuit, you claim that you're entitled to receive compensation because of somebody else's wrongdoing. The defense has an absolute right to have you sent to a doctor of their choosing to examine and evaluate your current injuries. Now, as your case progresses to trial, and once you're at trial, we have to put on whatever proof is necessary to prove your case. Since the defense has had an opportunity to examine you with a doctor of their own choosing, if they fail to call that examining doctor, there is a good possibility that we can ask the court to give the jury what's known as a missing witness charge. What does that mean? It means that the jury is allowed to infer the worst possible things and that we can now infer the strongest possible arguments against that particular witness. Here's a perfect example. If the defense refuses to bring in Dr. Jones, who examined you as part of their pretrial discovery, we can argue at closing argument, ladies and gentlemen, where is Dr. Jones? You would think that if he had useful information to offer against our claim, and to contradict the claims and the injuries that we're making in this case, don't you think that the defense would have brought him in? Of course they would have. Have they done so? No, they have not. Well, what can you infer from that? Assuming the judge is going to give a missing witness charge, the jury will then be told they can infer the worst because the defense did not bring in a witness to testify. And that's critical. Now, on the other hand, if we fail to bring in a necessary witness, the same can be held against us as well. The answer to the question is, are missing witnesses fair game when discussing this to the jury on closing arguments? The answer is absolutely. Having that missing witness charge is key to having the jury understand that they can infer the worst possible things because the defense has not brought in a witness that they should have brought in. So why do I tell you this? I tell you this to educate you, to teach you, and to give you an insight into how the legal process works and how the trial process works in cases involving accidents, negligence, and medical malpractice here in the state of New York. Chances are you have questions and concerns about your particular matter. So what I want you to do is pick up the phone and call me. I welcome your call. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.